My name is Mujonyo Yekunle, and it gives me great pleasure to welcome you to this webinar brought to you by Asset Management and UTL trustees. So we'll go right into the webinar. We're going to be discussing the importance of estate planning, and we have very knowledgeable speakers who are going to be sharing with us from their knowledge base and their years of experience. So for the session to be very impactful, we implore you to please put aside all forms of distraction so that you can be fully engaged. Please put your mic on mute at all times, and then if you have any question, please drop it in the Q&A box. It will be attended to. We have the pleasure of the presence of the MD, CEO of Outré Asset Management, Mr. Olabode. Over to you, sir.
Okay, thank you very much. We are really glad that we are all able to make it this evening. We know that we all must have really tried to find time out of our busy schedule to be available for meeting this evening. So I've tried to simplify the purpose of this meeting, and that is that the reason we're here is to try to determine what drama will play out when we exit. I mean, it's an unavoidable exit. Everyone will die. Although sometimes I hear people say somebody will not die in Jesus' name. I know that's a wrong prayer, because no one will come here and will not exit at some point. And there are two quick questions I would like to ask us. Do we want to be the author of that drama, the drama that will play out when we exit, in which case things will go according to our plan, hopefully? Or do we want to rather leave unknown authors to prepare the drama for us, which will mean we are risking ending up with typical Mike Adenuga's stories that touch. For some of us who are familiar with some of his, I mean, what do they call it again? That's the man who writes a number of all these plays that we watch on TV. So tonight, we do know that a number of us will be reminded of the importance of estate planning. Some of us already have some idea of what we are talking about, while others may be new to the subject. But there is one thing that we can assure of, and that is that from this meeting, we will all pick something, no doubt about it. One thing or two will pick from this meeting, which we can implement right away. So we are not in this meeting to just talk about all the usual, you know, all the technical jargons and all that. We're here to simplify the whole process about will writing, about estate planning. And we are sure that we'll all get one or two things that we can implement as soon as this meeting ends, or in just a matter of days after. Now, I would like to give us a quick background to what we are talking about tonight. Just some weeks back, we were discussing this all-important issue of estate planning. And from what I heard, I was really convinced that it's something that we need to share with much larger house. And that's why we're here this evening. And it's Outré, which is actually an investment company collaborating with UTL trustees to bring this service to all our clients, as well as those who are not even our customers yet. I must be quick to say that we'll open this meeting by acknowledging God first, because God is the author of all. And without him, there's nothing we can do. So we give all glory to God, who is our maker. Now, in this meeting, we'll find a number of things. The first one is that preparing and registering a will does not have to cost an arm and a leg. It's not a very expensive process in terms of the cost, which we'll find out in the course of this meeting. So, and in this meeting, we're able to present you with alternative that we can take advantage of, which will guarantee this low cost that we are talking about. So this will be made available, and we are saying that it doesn't matter whether you are rich or you are not quite well-to-do, but drawing a will is something that is really important and is what everyone should do. And we can assure you that it doesn't have to cost you so much for you to do it. So, and we are also saying that though the cost is low, there is even opportunity for you to get a discount. And how does that happen? If you come through Outré and you follow a low-cost option, which we'll present to you in the course of this meeting with a code, when you start preparing your will, you're able to even get a discount on the cost that is already low. That we can assure you. There is an alternative approach that could cost you a little more, where you don't on your own. It's like there is the do-it-yourself approach, which will cost you a lot less, while there is the one that if you must have the personnel or people do it for you, that could cost you some more. Now, some people think that they have too little to warrant preparing a will. But I can assure you that even if all you have is a pair of shoes, won't you rather determine who gets it after you have left? Then children, who have not attained adulthood, we are talking of digital, usually they will need guardians, they will need trustees for whatever is left behind that is meant for them. But there are this special group of people. I mean, we are talking of people who are challenged. They are not necessarily children. They could even be adults. But because of their peculiar situations, some children are autistic and some are in some peculiar situations, such that currently, maybe God has blessed us and we're actually able to give them the comfort that we can afford. But the question is, if something should happen to the provider of that comfort, would those people with special needs still have guaranteed help or care? So tonight we are going to see how, if we do it right, whatever they enjoy while you are here, they can still enjoy even if you exit, without this set of people suffering after we have left. Then there is an online platform. It has been designed to highly simplify this whole process. And what it does is to provide us with a step-by-step approach where you are able to answer some questions. I mean, there are questions and answers. It's a question and answer approach to drawing up a will. And we can actually bet on it that you will enjoy this process from start to finish. So I want to quickly hand over to UTL, and I'll show you that everyone here is really going to have a very pleasant time.
Okay, thank you very much, sir. You've made the speaker's job actually very easy. Thank you so much for that. So to get started, I'll be introducing our key speaker for today. She's the head of investment at UTL Trustees. Her name is Mrs. Taye Adelanwa. Over to you, Mrs. Adelanwa.
Good evening, ladies and gentlemen. My name is Taye Adelanwa. I work with UTL Trust Management Services. I believe they'll be working on my video. But I will just get started while that is being fixed. We have started late already. So like I said, my name is Taye Adelanwa. I work with UTL Trust Management Services, and I just want to thank Mr. Dr. Labode for asking us to do this with him, and that's why we are all here tonight. Tonight, we're talking about the importance of estate planning. And before I talk on the word estate planning, I would like to start from the word estate. Estate here in our context is not just referring to houses, landed properties. Estate means the entirety of what a person owns, all assets, whether they are tangible assets, whether they are intangible assets, whether they are life insurance policies, jewelry, cars, works of art, and so on and so forth. That is what constitutes a person's estate, everything that a person owns. So estate planning has to do with anticipating and arranging in one's lifetime how these assets will be managed, how they will be disposed of in a person's lifetime in the event of incapacitation and upon demise. And it's also important, and that's why we are going to be discussing that extensively tonight. I'm sharing my screen. So looking at the goals of estate planning, which is what we're looking at on this screen, we want to ensure fulfillment of personal goals. That's self-preservation, ensuring the fulfillment of personal goals. I'm sure we all agree that as human beings, we all have a survival instinct. We all have a survival instinct as human beings. So when we're talking about estate planning, we're looking at how to take care of ourselves. We want to ensure that we are properly catered for in our golden years in retirement. We want to be sure that we have a good plan for that time. We want to ensure that in the event of incapacitation, that we will not find ourselves in a place where we are unable to access the assets that we have, and as such, we are denied the proper care that we should have at that time. That is one of the reasons for estate planning, self-preservation. You know, some of us are also, going through seasons in life where advancing in our careers, we want to ensure that we get adequate care, proper care when we need it. We want to ensure that in our retirement, we are properly catered for. We want to ensure that we continue to earn an income. We want to ensure that our assets are preserved. And why do we want assets preserved? So that we can continue to take care of ourselves. So it's a survival instinct. Somebody says you really can't truly love others until we love ourselves. And I think it holds so true with estate planning. We really can't love others until we truly love ourselves. I recall sometime last year, one of our customers called in, and he was just expressing how sad he was because a particular friend of his did not have an estate plan, and he went into coma. He had over 30 million in his bank account, but nobody could have access to the funds, because he wasn't dead, he was alive, but unfortunately, nobody had access to his bank account. So family members were begging and going from from one friend to the other, seeking to raise funds. And I'm sure you can imagine that they did not raise sufficient funds. So the kind of care that he should have had at that time, given the kind of assets he had to his name, he really couldn't access it. Why? Because he did not have a proper estate plan in place to manage situations of incapacitation. We also have people that are rising in their career ladder, businesses are expanding, and you can't, you are building investment portfolio, but you can't keep up with managing these assets, and you need to delegate them to someone so that you can focus on your highest goals and priorities. And that is one of the goals of estate planning. The next one is the dependent security. We want to ensure that we make adequate provision for our loved ones. We want to ensure that we protect for nuclear family, provide for aged parents, or even members of extended family, other family members, or even perhaps employees that have served us faithfully, for several years. We might want to consider them in an estate plan. So one of the things we want to achieve in estate planning is that our dependents are secure. We want to protect the future. I'm sure we all have enough stories around us of people, who could not live the kind of life that, they continue to keep living the kind of life that they started out with because their benefactor died, their husband passed on, and because of that, some of them were chased out of property, had issues and so on and so forth. We want to ensure that we protect the future of the people that we love. Others will also use this to to provide for children from their previous marriages. The last one on this slide is entrenching of values. We want to ensure that you utilize resources for the things that you care about. We are all different individuals. We all have different values. Some people value education. Some people value health and wellness. Some people, value entrepreneurship. Whatever our values are, we can use a proper estate plan to drive those values, to contribute to society, to actually entrench values even in our dependents, with a proper plan. You can reward a particular type of value, you can reward certain behaviors, and you can also use your estate plan to voice your displeasure against even certain behaviors. The next thing I want to talk about is optimizing our estate plans. In optimizing our estate plans, it begins with the process of asset acquisition. At the point we are acquiring assets, we need to ask ourselves, in whose names am I going to be purchasing this asset? Because those things have implications. They actually have tax implications, especially upon one's passing. Assets are going to be passed, where they're in a will, assets passed in a will are going to attract certain charges. So because of that, we ask ourselves, in whose names do we want to purchase this asset? Is it in my name? Is it in a joint name? Or am I using a vehicle to acquire this asset? And all of that is to ensure that, you can minimize whatever charges that could crystallize in future where you want to have these assets duly passed on to beneficiaries. We also want to ensure preservation of assets. We want to ask ourselves, how do I present this asset from loss? You know, do we want to take insurance policies? Do we want to minimize probate charges? Because all of that can actually lead to a reduction in the value of the assets that we have and that we're able to pass on to the people that we love. And we're also looking at utilization of these assets. How are these assets going to be utilized? What intentions do we have? How do we want to dispose them? What plans do we want to put in place? What are our intentions? How do we want to continue to maintain lifestyle in retirement? What are the aspirations that we have for our family members, for our dependents? What do we see? What do we envision? What kind of life do we envision for them? All of that, you know, speaks to the intentions that we have regarding our assets. For the estate planning vehicles, there are different estate planning vehicles that we could use. Some of the things you also consider when having an estate plan is that given your existing work schedule, can you continue to manage your assets, or do you need to delegate, you know, to an independent manager? Do you have plans for healthcare? Perhaps you work in a particular institution where there are provisions for healthcare, you have healthcare facilities. What if the company changes their policy in the future? Would you still have adequate plans? As a business owner, as an entrepreneur, what plans do you have for succession? As a business owner, what plans do you have in place? If for any reason you are unable to act, are people going to, do you have a plan in place towards the management of finances, access to bank accounts, and so on and so forth? All of these things are things that we consider when we're having a plan. For those of us that have maybe beneficiary nominations, do we want to review this from time to time to be sure that the people that we have even on our beneficiary forms are people that are still in our lives? You know, they've not walked out of our life in one way or the other. Maybe there's been a divorce, maybe there's a loss of a loved one, and so on and so forth. You know, some of the things we want to ensure that we cover, putting together an estate plan. We have some of the estate planning vehicles. With the power of attorney, you're able to give, it's a legal document that actually gives somebody else power to act on one's behalf. And there are instances where this may be required. You know, we also have the deed of gifts, where you're making an arrangement to just transfer gifts to other persons without any consideration. And then you're willing to register the deed. You know, and when you do that, when you give a deed of gift, it's irrevocable. Again, it's an estate planning vehicle, but you also need to consider how you use it. Because since it's irrevocable, if you have given an asset to a spouse and the spouse, you know, at some point there's a divorce, that gift is also gone. So you also need to be fully aware and make sure that in utilizing any of these estate planning vehicles, you are properly guided and you fully understand the implications of what you're doing. It will help to save in estate taxes, you know, which is currently 10% of the value of one's estate. The deed of gifts is 3%, you know, so you will save now, but it has its own implications. So we also have the charities, where you are setting up charities. We mentioned earlier that one of the goals of estate planning could be to entrench values. There are things that we value. We want to give back. We want to live and leave a legacy. We want to give back to society. You know, I saw online while I was preparing for this that John D. Rockefeller, you know, actually gave $1 million to charity, like I mentioned earlier, you know, to eradicate hookworm in the United States, southern US to be precise. And eventually that led to the establishment of public health as we have it today. So that is one good that somebody did, you know, using resources. In going out and speaking with people about estate planning, we have met a few people who told us things like, oh, I've done everything that I need to do about my estate. I've given everything I need to give to my children. Perhaps if I have 1 or 2 persons online, maybe it's time to consider charity, that whilst in your lifetime or even upon one's passing, you can continue to do good. You can continue to make a difference. You can continue to add value to society in some way. Tonight, we are focusing mainly on the trust and wills, and we'll just go right into that. With a trust arrangement, a person is able to transfer assets to trustees for the benefit of one or more beneficiaries. You know, and the example I like to give is the boarding house mistress. I don't know how many people attended a secondary school with a boarding house. I did, and we had boarding house mistresses, you know, and it was the pattern that some parents, mothers' parents would just give some funds to the boarding house mistress to be used, you know, by the ward in the course of a term, you know. And then from time to time, the children will go to the boarding house mistress, maybe to ask for money for provision, a few stationaries, and so on and so forth. You know, but if a child comes and asks for makes a frivolous request, that is not in line with what the instructions the parents have given concerning the administration of the funds, then it will not be honored. So a trust is like a similar arrangement. You know, in that, boarding house mistress is like the trustee who is holding the asset. The children are like the beneficiaries, and the mother is the maker of the trust and is called the settler of that trust, is the person funding that trust. So basically, you have three main parties to the will. You have the maker, that is called the settler. You have the beneficiaries. You have the trustees. In a few instances, people also add another party that is called protector. You know, protectors are not mandatory. If you want to have them, you can have them. They act as watchdogs over the operations of the trustee regarding the trust. So unlike the boarding house arrangement, wherein, you know, it's just a gentleman agreement, this is a legal agreement, you know, and there's a trust deed that governs what needs to be done. The intentions of the maker of the trust or the settler of the trust is clearly spelled out. The obligations and duties of the trustee regarding the trust is clearly spelled out, you know, and the trust can be set up as revocable or irrevocable. I mentioned earlier that having a protector is not mandatory, you know, and it's not mandatory because really a trustee has a fiduciary duty towards their clients. They have the duty of care, and they are to use their knowledge and expertise to act on their clients' behalf. And that is why the client has reposed such confidence and trust in them. It's to be used to act in the client's behalf. So because they have a fiduciary duty, they are to act solely in the interest of the person that has engaged them. And that is why, with or without the protector, they will still do what they need to do under the trust. So the types of trust, we have the living trust and the testamentary trust. Those are like two broad categories of trust that we have. With a living trust is a trust that one set up in one's lifetime. So we can set up a trust in one's lifetime. Like the cartoon that we have here, you know, these two children are having a dialogue. Daddy set up a trust to help us avoid the delay and the expense of probate. That's like one of the benefits, you know, of a trust. Then the trust gives clear directions on how his assets should be distributed after his death. Then in one other place, it says, you know, you don't mean that the daddy gave me the painting or something, you know, and he said, I warned you not to do that. You know, that is speaking to the fact that you can actually use your estate plan arrangement to drive the things that you value. So a living trust is a trust that one makes in one's lifetime, that takes effect in one's lifetime, and it can be used for a myriad of purposes. You know, it can be used for a myriad of purposes. You can use a living trust to manage assets in your lifetime, to manage real estate businesses on one's behalf, fully delegated to the hands of a trustee. You can, you know, earn periodic income from the assets that are put into the trust. You can use a living trust to manage education trust or even the related obligations. For instance, we have people that have children abroad, you know, that fund an education trust for their children that are schooling abroad. So we take the responsibility of them, of the school fees, of monthly allowances, and so on and so forth. We can also use a living trust to manage, you know, what Mr. Olabode had mentioned at the beginning. We can use it to manage spendthrift children or children that have special needs. Where a child is not particularly good with managing money, or where, you know, a trust that can be factored in when setting up a living trust, such that everything relating to, what that child should have access to can be put into the hands of that trustee, and periodically allowances can be paid to such child, allowances can be released for upkeep, bills, medical bills, house rents, children's school fees can be paid even from that trust, and so on and so forth. All of this would just mirror the intention of the person setting up the trust arrangement. In the case of special needs children, we say we can also put that even in a living trust, fund the trust sufficiently such that such needs are covered. Where we have special needs children, one of the reasons why people consider trust is that maybe they don't want to burden other family members, with the welfare of that child, or they want an independent trustee to still help them to oversee, even upon their passing, the welfare of this child. They can use a living trust to drive that. You can also set up living trust and have charitable causes embedded in there when you fund them. Another thing you can achieve with your living trust is that the proceeds of life insurance policies, those that are payable in one's lifetime, are the ones that can come into the living trust. You can put them into a living trust for proper management. We also have the testamentary trust. The testamentary trusts are the trusts that are set up in a will. The trusts that are set up in a will, really broadly speaking, a trust can really help you to achieve anything that anybody can do on your behalf. You can practically use a trust to set that up. So you have the testamentary trust that is embedded in a will. So it only comes into effect upon one's passing. So while you can use the living trust to achieve as self-preservation objectives, you may not be able to use the testamentary trust because it takes effect after one has gone. The living trust can also be used to manage things around incapacitation. For instance, the example I shared, if that man had, just 10 million out of his funds in a living trust, the family members would have been able to have access to it. Immediately he went into coma, and they would have been able to provide whatever support that he needed. So the importance of having a trust, we want to ensure proper management of makers' affairs and also of beneficiaries. We're able to have professional management of assets. We're able to ensure accountability and transparency in the management of trust assets. Another thing we need to note about trust is that they are confidential arrangements, they are private arrangements, and you are also able to avoid the rigors of probate and probate charges on this asset. And like I've mentioned earlier, you are able to also delegate responsibilities and focus on higher priorities, when you have some of this trust set up. That is the living trust in this instance. The next estate planning vehicle we're looking at is the will. So it's a document that basically is used to transfer or manage assets for the specified beneficiaries. It only takes effect upon the passing of the maker of the will, and the parties to a will is a person making that will, who is called the testator. The persons that are appointed by the maker, that is the executors of the will, that are appointed to carry out the instructions that have been laid out in the will. We also have the people that are going to be benefiting from the will, that are called the beneficiaries. We also have guardians that are appointed to take care of minors. Mr. Laborde mentioned that earlier. We appoint guardians to take care of minors. So like I mentioned, the will only comes into effect upon one's passing. One of the things that we hear is, when I make a will, will I still be able to deal on my assets? Will I be able to sell? The truth is, you are able to have access to your assets because there is no transfer of title when you are making a will. Let me just state that when you're putting anything in a trust, there has to be a transfer of title for you to effectively have anything in a trust. But in the case of a will, it's just a document saying, these are the things that I have. These are my instructions. These are the assets. This is how you should administer those assets upon my passing. These are the people appointed to ensure that my wishes are carried out. So talking about the content of a valid will, it will contain the full names of the testator, the full names of the beneficiaries. It will contain the names of the executors and their addresses. It will contain, the names of the witnesses to the will. It will contain the complete listing of the person's assets and also how these assets should be distributed. We need to note that it is important that the list that we have, the list of assets, are comprehensive, because anything that is not listed in the will is not in the will. So, and because it's not in the will, that means it's as if one has died intestate regarding those assets. The laws of intestacy will apply concerning those assets that have not been captured in the will. So we want to ensure that we sit back, relax, and have a comprehensive list of the assets that we have. One of the things that we discover in talking to people about their assets is that sometimes when you tell people to just even make a list of their assets, they forget some bank accounts that they open, some foreign bank accounts they forget, they forget, some properties that they bought at some point in their lives, so when you're making a will, you want to just sit down, relax, and ensure that whatever you're doing is actually comprehensive. For you to have a will that is valid, it has to be in writing. You must be at least 18 years of age before you can make a will. The person has to be of a sound mind. The person, must not be seen to be under any form of undue influence when making the will. And whatever wills that must be valid has to be properly executed. The lawyers will guide you appropriately in this. Now, wills can be a very simple will where somebody just says, these are the assets that I have and this is how you should distribute them. Or it can be complex. Somebody wants to give a lot of instructions regarding, somebody, number one, has so many assets and then has so many instructions regarding how those assets should be distributed. Maybe he wants to distribute some, wants to dispose some, wants a testamentary trust for the management of some of the assets, and so on and so forth. So a will could be simple. A will could also be comprehensive in nature. Whatever you're making, whether you're making a simple will, whether you're making a comprehensive will, we can walk you through that process. And like Mr. Labode mentioned at the beginning, sometime last year, February, we actually launched our online will writing platform, that is Willpower. It's a platform for online will writing. It's a do-it-yourself platform, and it's particularly very good for simple arrangements. You just have assets, you want to distribute them, you can use Willpower. And like you mentioned, we have some discounts that we have offered for people that are going through Outré to make those simple wills. If the wills are complex, like we had a particular client that in putting his will together, it was still trying to use the will to entrench the things that value to him, like lifestyle, the lifestyle. So he has provisions for vacation for the wife, annual allowances, what we should give to them at festive periods, and so on and so forth, and even gifts that we should give, when people are getting married, and so on and so forth. It was quite an elaborate arrangement. So I want us to know, before I go on to wills and or trusts, that if a person dies without making a will, the person is said to have died intestate, and nobody wants to be in that place. Nobody wants to be in that place where their dependents upon their passing cannot have easy access, to the things that they own, because that is one of the things that estate planning allows, helps you to achieve, that dependents can have easy access to resources. But when people pass on without a will, then they allow the laws of the land to take over, or customary laws to take over. And when these take over, you can be sure that it's unlikely that the assets will ever be distributed in accordance with your own personal wishes, your own personal intentions regarding, the assets. And that is why we have a lot of issues, people thrown out of families, female children not being cared for in some cultures, spouses, being disinherited, and so on and so forth, because people, did not have a firm arrangement. I also want us to know that in obtaining letters of administration to be able to deal on the person's estate upon passing, practically any close relative can actually make those applications. You know, is it the spouse, is it the mother, is it the uncle, is it the auntie, is it sisters or half-blood, sisters and brothers, even sisters and brothers that are half-blooded, you know, and the list is practically endless. So if you are from a very big family, you can multiply the number of people that can actually come forward, you know, and apply for letters of administration. Because of that, we want to ensure that we avoid intestacy. You know, we want to ensure that people have easy access to our assets. So that's one of the major importance of having a will in place. I also want us to know that people that have retirement savings accounts, the provisions of the Pencom Reform Act of 2014 is that balances in retirement savings accounts can only be accessed through valid wills or letters of administration. You know, so for everybody that has a retirement savings account, I mean, it just means that you should have a will. You know, it's just that they've not made it mandatory. But I think by the act, it's more or less something that we need to consider very critically. Because when people then go to these pension administrators, that is what they are going to ask for. They're going to ask if there's a valid will. They're going to ask if there's a letter of administration. Even the involuntary savings that we are contributing, you know, I'm sure they're still going to make the same request upon one's passing. They're not just going to pass on funds. You know, so because of that, we want to avoid intestacy. We want to ensure that assets are distributed in accordance with our intentions. I mean, you have worked so hard already. You have acquired these assets already. You know, some of the things we also meet is that people tell us things like, well, I don't mind my custom, you know, and so we've met a few people that, you know, have some kind of sympathy for their custom, you know, but what we are saying is that no matter who you are, you know, whatever sympathy or regard you have those customs, when you write your plan, you can capture all the diverse interests when you write your own plan yourself. Then you will be able to understand that, oh, you have minors, you need to make provisions for them. You need to make provisions for that woman because maybe you told her she shouldn't work or whatever. You know, you need to make provisions for the people that are dear to you. And then you can still cover your brothers or your sisters when you make a proper plan. Somebody shared a story with me once about the brother that passed. So he said his brother passed on, and then the wife applied for letters of administration over the estate, and she got the money, and then she remarried. You know, and then he was then asking, what if that brother was the only son of the mother? So when it comes to things around writing wills, nuclear family, all of us have different you know, we are sympathetic to different causes. But what we are saying here is that when you are in that place to make your own arrangement, you'll be able to know this is my own unique situation and circumstance, and how can I ensure that everybody is properly covered. I'm the only child, and I have aged parents. In the event of that anything happens, how do I ensure that my aged parent is covered? How do I ensure that my spouse is covered and the children are covered? A proper plan allows us to be able to give in line with our intentions. And with a proper plan in place, we're able to give legal access, not illegal access. There was a particular person that said, well, how much do I have in the bank? I'll just give them the ATM. They'll go and make withdrawals. I'm sure we all know that each time you are given an ATM, you are told not to disclose your PIN to anybody. You know, I'm sure we get that message every time. It is because it's supposed to be our personal PIN for our personal transactions. Upon one's passing, it is highly illegal for anybody, even if you were doing it in the person's lifetime. You know, it becomes highly illegal when the person is upon their passing to pick their card and begin to make withdrawals, because the law would come after you. So we're able to protect the loved ones. We're able to manage diverse interests. So looking at the wills of trust, just comparing the two documents. So the will is a public document. So once the will is read, it's confidential until the point when it is read. After the reading of the will, practically anybody can apply for a copy of that will. So whatever it is that you have, one has distributed, the manner of distribution is accessible, you know, to people. You know, so because it's a public document. However, the trust is not public. It's a confidential arrangement. In one's lifetime, upon one's passing, it remains a confidential arrangement. The will is purely used for assets distribution unless there is a testamentary trust, that is embedded within it, So, but ordinarily, it's a will for distribution of assets. But a trust can receive assets, can manage assets, can be used to optimize portfolios, and can then also distribute assets. Wills comes into effect upon the passing of the testator, whilst a living trust can come into effect in one's lifetime. Like I mentioned earlier, with a will, one will not be able to achieve the goal of self-preservation, definitely, with a will, but with a trust, you can, actually ensure self-preservation. You can take care of yourself, plan for incapacitation, and have, things, and ensure that you are properly catered for. For the will, there's an aspect of the trust. A trust will require an initial capital fund. If there's no asset in a trust, there's nothing for the trustee to manage, then it cannot carry out any obligation. In fact, there is no trust unless there's an initial capital fund. So wills are also subject to probate charges. We say that today, when somebody passes assets that are listed in the will, there's a 10% probate charge that is applied on it. So if your asset is worth 200 million, there's a 20 million that becomes payable to the government. But whereas if you had the same 200 million in a trust, it's already shielded from probate charges. For the trust, transfer of title is immediate. So if you're looking at putting properties in a trust, and that's why we said at the beginning that it's important to look at the point of acquiring those assets, one wants to look at how one wants to buy them, whether we want to buy in one's personal name or whether you even want to buy in the name of a trust. So should I use a will? Should I use a trust? Basically, we usually recommend both because they serve different purposes and just helps you to have a more robust plan. If you have properties already existing in your name, if you're transferring into a trust, you might not be ready to bear the charges that are associated with such transfers. So you might want to leave them in a will and just know that in the future, when it's going to be, subjected to probate, all of those charges would apply. If you have retirement savings accounts, you have balances in your voluntary contributions, it is important that you have a will in place because of the provisions of income like I earlier mentioned. Also, if privacy means a lot to you, you don't want somebody to be able to get a copy of the arrangement that you have made, it is important to you that your distribution is just strictly between you and your agent, then you might need to consider a trust, and then the cost of the trust, might not be so important to you if privacy, is of a priority. Some of the things that people do to be able to achieve that sometimes is to sell off, some of the assets they have and then purchase new assets in the name of a trust, and then they are able to properly give instructions under the trust as to how those assets should be distributed or should be managed. One of the things we also want to ensure in having a trust, I mentioned the fact that there should be a fund, for you to be able to say you have entrusted assets into the hands of a trustee, that there should be an initial capital fund. The guide is the objectives of the trust. So what are the objectives of the trust? What do you want to achieve by setting up this trust? If you want to set up a trust for education and you already have an idea, of what the obligations are going to be, then it should dictate what you are having as an initial capital fund or subsequent payments that you want to put into that fund. If you're setting up a trust, for instance, to be able to step in the case of a health crisis, then you need to be able to ask yourself, in the event that there's a major health crisis and we need to have proper care, what kind of fund would be required? And that should speak to what we are putting into the trust, so that if, for instance, somebody needs to be flown abroad, needs to access medical care abroad, how much would that be? If you then put an amount that cannot deliver on those objectives, you have not fully effected a trust that can take care of your wishes. So these are some of the benefits of estate planning. We want to avoid intestacy proceedings. We want to avoid intestacy proceedings. We have talked about that. You know, we also want to ensure that we properly identify assets so that they are protected from, you know, persons that can prey on them. You know, we want to ensure asset identification. And it's so big because when people pass on without a will, the first step is then to begin to try and ascertain what they have, what they own, because there's no document stating this is exactly what it is. You know, we have instances where we have to write to all the banks in Nigeria. Can you imagine that? You know, before we can start gathering people's assets. But if the person in his lifetime says, I have money with bank A, bank B, bank C, bank D, then the population is known. You know, so we want to ensure asset identification and protection. I recall a friend of mine, we spoke along this line. She works with a real estate firm. And she told me that sometime in the office, a particular man came to them and was kind of lamenting and said, oh, this house you are building for me, you know, you don't want me to live in it or something like that. And they didn't really quite understand what the man was saying. But after maybe a couple of months, the man passed on. And at some point, it was as if they discovered that their company was trying to convert that asset. If that man never had a document stating where his assets were, they would never know that he had such investments in that company. And can you imagine how many people buy houses wanting to surprise spouses or surprise people, you know, and just, you know, they don't have a document and then they pass and nobody knows that those assets exist. A proper plan allows for asset identification. In this particular story, one of the staff decided, you know, because they really felt bad, they knew that the man had the house. They went to the wife and they asked, do you know your husband's assets? You know, where does he have, you know, they saw something. And the woman said, he told me he had this, he had that. The man did not include the one that they were aware that he also had paid for. So we want to ensure that assets are identified and protected. We want to ensure that distribution is made to intended beneficiaries. You know, while I was just saying this, I just remember the particular story of somebody, you know, who had children in, you know, one of the big schools on the island. And then the man passed on. Then the brother came and took the children to the village and locked up the house. And they did not see the children for years. And parents had, I understand, they had set up some kind of trust arrangement for them, though they could not even locate these children, you know, because the man did not have a plan, you know, in place as to how assets should be administered. So we want to ensure that distribution is to intended beneficiaries. We want to ensure that we are able to ward off people that just want to meddle with what belongs to us. We want to also avoid drama, like Ms. Alabode put it at the beginning. We want to avoid family drama, family conflicts. You know, we can avoid them. We can avoid them by simply having a good plan. You know, and like I said, whatever interest you want to cover, it's your plan, it's your document. You can, as much as possible, make sure that you take care of the people that are dear to you and you're able to accomplish what is important to you. All right, so like I mentioned earlier, we have willpower. Willpower actually won the, we had 3 awards last year. It's a triple award-winning application. It won the Business Day Award for the best non-banking financial product. So you can go to Willpower to make your simple arrangements where you have assets, you just want to distribute them. You can go to Willpower to make your simple arrangements. Online, Willpower is 50,000. If you go through Outré, you get some good discounts, so you can speak with them. We also have our offline services where you have a robust estate. That fee varies from person to person depending on, you know, the size of the estate, what you want to do, the obligations you want the trustee to perform in that arrangement. So looking at the online process, basically when you go online is a simple 5-step process. I mean, it's so simple. It's a simple 5-step process. You want to be able to create and verify your account online. You want to be able to choose your plan. And once you choose your estate plan, You know, online, you can actually make a will. You can make a will on your retirement savings account. If that's the only asset that you have, you want to put in a will. We have a will for retirement savings account. We have a will for simple wills. You can also create your trust online, you know. So once you get there, just choose a plan, enter the necessary information, then you'll be able to pay, print, sign your documents, and then send to UTL. We actually have arrangements with DHL companies, with DHL, so you can just enter any of their offices and send those documents to us. When they come to us, our lawyers will look at them in-house and then review them, and we'll get back to you if there's anything, you know, and if there's nothing, if it's okay, we'll then help you to lodge those documents at the probate. You know, so, but if you want an offline arrangement, you can either contact us directly in UTL, or you contact Outré Asset Management. They will still link you up with us. You know, we'll then be able to work with you to know, you know, your specific situation and circumstances, you know, give you whatever form that you need to fill, walk you through that process, and then we're able to give you a draft of your documents. You know, you will go through the draft. There'll be a bit of back and forth until the document captures your intention completely, and then you can then forward those documents to us. All right, so that's the end of the presentation. I have my colleagues online, Mr. Eko Mumoso and Mrs. Bolande Komolafe. They're going to be taking the questions and the answers.
Thank you very much, Mrs. Adelanwa. We have a question in the chat room. I will just read that out now, and maybe Mr. Moso can respond to it. So the question is from Moyosore Odeniyi. She says, does the estate form part of the initial capital fund in a living trust? What is the best approach to avoid charges on a will for assets which have already been bought in my name? Is it the most cost-effective to transfer to a trust now, or just treat as part of a will?
The first question is, does assets form part of the capital fund? You see, in the trust, once you create a trust, it is, you know, mandatory that there must be assets in that trust. And whatever assets that you've put in there forms part of the capital fund. But we advise clients that even if you have these assets, you know, like maybe you have some cash in banks, maybe you have vehicles and things like that, we still advise that you put physical cash also as to form part of that capital fund. You know, we give this advice because depending on the objective of that trust, you know, if it is such a trust that says, do this for my children in school, that means there must be money handy to take care of those, the needs of those children in school. So in as much as the assets listed form part of the capital fund, physical cash could also be, you know, brought into a trust, and which will still form part of that capital fund. Now, on the other question, that what are the best approach to avoid probate charges on a will, I'll take it, you know, bit by bit. You know, what we do to our customers is that because we know that there are these probate charges that must be paid, we advise our customers, look, depending on the complexity of your estate, we advise do both the will and trust. In that circumstance, we will be in a better position to advise you the assets that you can put in the will and the assets you can put in a trust to reduce the probate charges on you. You know, and again, there is this issue for assets which have already been bought in your name. Well, it all depends on the type of assets that you bought in your name. You know, if it were to be just the real estate, you know, that you had bought already in your name, well, we can advise why not go for a will. However, it's not as if one cannot put real estate into a trust, but we have to explain to you the cost implication of transferring title of real estate to the trust. So when you weigh the two options, one will decide, can I go for a will or can I go for a trust, depending on the cost of transferring, because from what my colleague has said, once you create a trust, the law expects that you must transfer title to the trust. So to transfer title to real estate to a trust may be onerous, and we advise in such circumstance, why not pick a will and then do it? I think, are those just the two questions?
Okay, thank you very much, sir. The next question is for Bolanle. So he says, Ihoma says, what's the financial implication of putting existing assets into a living trust?
Thank you very much. The financial implications of putting existing assets into a living trust. So for instance, this is going to depend basically on the type of assets you're putting in the trust and then the value of the assets. There are some assets that all you need to do is name them in the trust, such as bank accounts. You just name them. There's no immediate cost as to transferring them into the trust. But when it comes to assets such as real estate and titled assets, there are costs which is associated with the value of the particular property. So this is something that we can always take up with people offline when we get more details as to the value of those assets. Because there are third-party charges that is related to this transfer. So it's going to depend on the value of the asset that you're transferring. Thank you.
All right, thank you very much, Bolanle. The next question is for Mr. Omoso. So it says, if I gift the asset to my child, does it still attract probate charges?
If you give your
to
your child.
If I gift the assets,
Okay.
yes, to my child, does it still attract probate charges?
Now, that means you have made a gift to that child. You've taken this particular asset, you have given it to that particular child. In such circumstance, we would generally advise that because you have done this gift, possibly maybe you did a deed of gift and you pass that particular asset to that child, we can advise you in such circumstance, since you have already passed title or ownership to that child, there is no need to even bring such an asset into a will. You've already transferred title, you've passed, you make a gift to that child. So you don't need to bring it into the will, because the moment you bring it into that will, upon probate, you will be asked to pay. Thank you.
All right, thank you very much, sir. I don't know if we have further questions. Any other questions, please? If you would like to, say your questions, aside putting it in the chat room, can you unmute your mic?
Okay, quite a number of people have been asking if we have this meeting recorded, that they would like a copy of the video shared with them. So I need a response on that.
Yes, sir. Yes, we do. We have it recorded, and yeah, we can share it after the session. Somebody is asking, what is UTL's cost of administering a trust? Did you hear the question, sir?
UTL's cost.
Yes, sir.
Exactly, I did. Yeah, the cost of administering a trust. We have, in administering a trust, our fees are categorized into heads, subheads, and all the fees are, I would say, they are not cast in stone. Fees are negotiable. Whoever that needs to do a trust, we sit together and we discuss on fees. Since I have said it's not something cast in stone, we negotiate to arrive at a fee that is good for whoever that comes, that's for the clients and to us. So there is no hard and fast rule about fee. It is something we can sit down and negotiate. Thank you.
Okay, thank you very much, sir. I have one more question from Olufunke Adebayo. The question says, how important is the periodic update of an existing will? E.g., a will was created 5 years ago, will not have an up-to-date list of assets as of today.
Yes, thank you very much. It is something that we advise our clients that you can amend your will at any time. You can update your will at any moment. It all depends on what you want. There are people that create the will today, and tomorrow they have other assets to bring into that will. I've seen a situation that one creates a will today, 2 weeks thereafter, he had other assets to be brought into it, and he came back to us to amend that will. So it is important to keep your will up to date. 1, you may have new assets. 2, you may have new beneficiaries to bring in. You may have other things to amend, to change, in your will. So at every moment, you can amend your will to make it up to the standard that you want, to update it from time to time, to ensure that all the information and details that's supposed to be in that will are there. So at any time, you can do it. It is extremely of essence to have it updated from time to time in order to put all the information and details, assets, beneficiaries in it.
Okay. All right. Thank you very much, sir. Do we have time to still take more questions? I have 2 questions that just came in now. So I'll read the first one. So the person is apologizing for joining late, and it says, please, are you saying 20% of the assets in a will goes to the government after the passing of the owner of the will?
What we are saying is, each state of Nigeria, every state has their own wills laws. They have their own probate processes, rules guiding, probate matters. Like in Lagos State, it is known that probate charges is 10% of the assets. Other states may be higher. There are states that charge up to 15%. So it varies from state to state. But in Lagos State, probate charge is 10% of the assets value. Thank you.
All right, thank you, sir. So the last one now, I think, is a continuation of the question on how often a will, has to be updated. So the person says, how does it transpire in a case of the demise when the update is not done?
If someone, does not update his will, and then the person passes on, what is there is that what is in the will would, go through the probate. In some instances, if certain assets are not captured in that will, maybe the person, the maker of the will, had bought these new assets and never had time to forward that information for his will to be updated. Those other assets that have not been brought into the will can pass through, probate via letters of administration.
On the issue of how often people can change their will, though it was stated that it's your right to make changes, let's also be mindful of, well, as an investment consultant, I believe that whatever we want to do is always good to think in terms of how much it will cost. So you don't change your will the way you change the contents of your personal diary, where you do your daily recording and all that. Every time you make an attempt to change a will that has already been completed, there's always the cost because it has to be registered. Until that change is registered, it's not effective. So that means that by all means, you want to be as coordinated as possible and plan it so that you can make the changes you want. within a reasonable interval that will ensure that your intentions are documented and they are registered. Again, if the cost doesn't matter to you, you can change it every day as you like. The professionals are always available to handle it for you for as long as you meet all the requirements. But definitely, cost is it's important to every human being that I know. So that means that we need to actually make sure that we plan it well so that we can make as many changes as we want and ensure that those changes are reflected. So good to have proper intervals to do it so that you don't incur unnecessary charge in the process. Because every time you make a change, it has to be registered, and every registration has a cost involved. Thank you.
Okay, thank you very much, sir, for that addition. So we can bring the session to a close. I would like to say thank you to everyone on behalf of the MD, CE of UTL Trustees, Mrs. Olufunke Ayekola, and the MD CEO of Outré Asset Management, Mr. Olabode. I'd like to say a huge thank you to all our panelists, our attendees today. I'm sure that we've learned a few things that we'll put into action going forward. It's an evening well spent. Thank you everyone for attending, and good night.